Section 14. Barangay Protection Orders, BPOs, who may issue and how. Barangay Protection Orders, BPOs, refer to the protection order issued by the punong barangay ordering the perpetrator to desist from committing acts under Section 5A and B of this Act. A punong barangay who receives applications for a BPO shall issue the protection order to the applicant on the date of filing after ex parte determination of the basis of the application. If the punong barangay is unavailable to act on the application for a BPO, the application shall be acted upon by any available barangay kagawad. If the BPO is issued by a barangay kagawad, the order must be accompanied by an attestation by the barangay kagawad that the punong barangay was unavailable at the time for the issuance of the BPO. BPOs shall be effective for 15 days. Immediately after the issuance of an ex parte BPO, the punong barangay or barangay kagawad shall personally serve a copy of the same on the respondent, or direct any barangay official to effect his personal service. The parties may be accompanied by a non-lawyer advocate in any proceeding before the punong barangay. Section 15. Temporary Protection Orders. Temporary Protection Orders, TPOs, refers to the protection order issued by the court on the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a DPO any, some, or all of the reliefs mentioned in this Act and shall be effective for 30 days. The court shall schedule a hearing on the issuance of a PPO prior to or on the date of the expiration of the DPO. The court shall order the immediate personal service of the DPO on the respondent by the court sheriff, who may obtain the assistance of law enforcement agents for the service. The DPO shall include notice of the date of the hearing on the merits of the issuance of a PPO.
Earn passive income from sales by promoting product links of Shopee, Lazada, Zalora, among others. Just generate the affiliate link and post it in your social media. If someone buy, you will earn commission. Check out the link on the description to get rewards.
Section 16. Permanent Protection Orders. Permanent Protection Order, PPO, refers to protection order issued by the court after notice and hearing. Respondent's non-appearance despite proper notice, or his lack of a lawyer, or the non-availability of his lawyer shall not be a ground for rescheduling or postponing the hearing on the merits of the issuance of a PPO. If the respondent appears without counsel on the date of the hearing on the PPO, the court shall appoint a lawyer for the respondent and immediately proceed with the hearing. In case the respondent fails to appear despite proper notice, the court shall allow ex parte presentation of the evidence by the applicant and render judgment on the basis of the evidence presented. The court shall allow the introduction of any history of abusive conduct of a respondent even if the same was not directed against the applicant or the person for whom the applicant is made. The court shall, to the extent possible, conduct the hearing on the merits of the issuance of a PPO in one day. Where the court is unable to conduct the hearing within one day and the DPO issued is due to expire, the court shall continuously extend or renew the DPO for a period of 30 days at each particular time until final judgment is issued. The extended or renewed TPO may be modified by the court as may be necessary or applicable to address the needs of the applicant. The court may grant any, some, or all of the reliefs specified in Section 8 hereof in a PPO. A PPO shall be effective until revoked by a court upon application of the person in whose favor the order was issued. The court shall ensure immediate personal service of the PPO on respondent. The court shall not deny the issuance of protection order on the basis of the lapse of time between the act of violence and the filing of the application. Regardless of the conviction or acquittal of the respondent, the court must determine whether or not the PPO shall become final. Even in a dismissal, a PPO shall be granted as long as there is no clear showing that the act from which the order might arise did not exist. Section 17. Notice of sanction in protection orders. The following statement must be printed in bold-faced type or in capital letters on the protection order issued by the punong barangay or court. Violation of this order is punishable by law. Section 18. Mandatory period for acting on applications for protection orders. Failure to act on an application for a protection order within the reglementary period specified in the previous section without justifiable cause shall render the official or judge administratively liable. Section 19. Legal separation cases. In cases of legal separation, where violence as specified in this Act is alleged, Article 58 of the Family Code shall not apply. The court shall proceed on the main case and other incidents of the case as soon as possible. The hearing on any application for a protection order filed by the petitioner must be conducted within the mandatory period specified in this Act. Section 20. Priority of application for a protection order. Ex parte and adversarial hearings to determine the basis of applications for a protection order under this Act shall have priority over all other proceedings. Barangay officials and the courts shall schedule and conduct hearings on applications for a protection order under this Act above all other business and, if necessary, suspend other proceedings in order to hear applications for a protection order.